Mike.
We're live.
Okay,
Oh,
we're in, this is the House Judiciary Committee. And we are having our first voting session of the 2021 session. And we're going to deal with quite a few bills, some of which are being withdrawn, but it would be helpful if I actually didn't put it somewhere else at the moment. But what are you going to do? Here it is. Okay, so what we're going to do, there are some people who are going to have to get on and off because they are getting vaccinated. And I believe actually that Delegate Conaway is getting vaccinated. He is on his way coming back to get on his computer here in a moment. So initially I thought we'd do this the other way, but maybe it's better to do this. We have 3 bills that are withdrawn already, which, there you go. These 3 are House Bill 42, House Bill 230, and House Bill 331. Is there a motion?
so moved.
There's a motion presumably for an unfavorable, withdrawn.
Yes.
Motion and seconded for if anyone seeks to vote against the unfavorable motion, Delegate Cam, this is for the new people, listen carefully. You're voting against the unfavorable motion, then please indicate by, I'm going to try it this way for some of the things that are going to go faster, by using the raise hand feature in the Zoom. In other words, if you don't want the bill to be withdrawn, use the raise hand feature in the Zoom. Seeing none, the bills are withdrawn unfavorable. Now, there are 3 bills, oddly, all of which are Delegate Chetty's bills. I think that did not have any opposition last time and did not have any opposition this time, and I think moved out unanimously. These are House Bills 9, 39, and 347. It's the chair. The chair is seeking to move all 3 of these on a consent docket. Is there
consent.
Is there
Second.
A second.
Okay, it's motion
Can
and
we-
second
Can
for
you read the
favor.
titles?
House Bill 9 is family law mandatory reporter training. This is requiring a video to be put on, I can't remember which website all of a sudden, but it requires, let me get that file. House Bill 9 requires the Department of Human Services to post on its website a free online course in the identification, prevention, and reporting of child abuse. House Bill 39 is the waiver of the publication requirement for name changes. And House Bill 347 is exploitation of vulnerable adult or elderly individual undue influence. It alters the definition of undue influence in the context of the exploitation of a vulnerable adult. Those are the 3 bills. They each moved. House Bill 3 last year was 19-0. House Bill 39 was 19-0. House Bill 347, I believe, was unanimous in the end. It was 20-0.
Okay.
Well,
Okay.
does anyone wish a motion to move any of these bills off of the consent docket? Seeing none, a vote for, when I do the roll call next, a vote for the bills is a vote for all 3. This is 9, 39, and 347. Everybody got that? I believe the motion was for a favorable and there was a second. Here we go. The Vice Chair.
Yes.
Anderson.
Yes.
Erican.
Yes.
Bartlett.
Yes.
Cardin.
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes.
Lopez,
Yes.
Malone. Mike? Say again, Mike?
Yes.
Okay. McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Watson,
Yes.
Williams.
Yes.
All right, 21. All right, all three of those are done. See, this is easy. All right, now we are going to House Bill 100. This is Delegate Deborah Davis's bill. I believe we moved this bill last year. And it has to do, is this the study? Yeah, this is the inmate cost of living report from MCE.
Move favorable.
There's a motion for a favorable. Is there a
Second.
and a second? Is there discussion on the favorable motion for House Bill 100? If you want to discuss something, by the way, you're going to hit the raise hand feature and then I'll recognize you from there. But seeing none, there's a motion and a second. We'll do the roll call. The vice chair,
Yes.
Anderson,
Yes.
Erican, Lauren Erican, House Bill 100.
Somebody muted me. Yes.
Okay. Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Watson,
Yes.
Williams.
Yes.
All right, that's 21. By the way, a couple minutes ago was, I think, the first time the Delegate Cham voted for something in the legislature.
Hey!
Thank you. Thank you.
Yeah, a minute and a half.
She voted the right way and everything. I don't know. Right.
I just pay attention, and I've been reading like insatiably.
All right. All right. Okay, so now we're at House Bill 147. House Bill 147 the exemption from prosecution for sexual crimes if at the time of the alleged rape or sexual offense, the person was the victim's legal spouse. So the issue is, it relates back to consent and the repeal of the spousal defense. It says that if you're charged with rape, but you're married to the person who you are alleged to have raped, that you can claim a defense that says I'm married to them. So it would.
Favorable. Second.
There's a motion for a favorable and a second. Is there discussion on the bill? Delegate Cox.
Thank you, Mr. Chair. Just wanted to restate what I said last year, and that is because it also removes 3308, which is the touching. I'm going to be a no again.
Okay. Delegate John Cardin.
Thank you. I just wanted to mention to the body that you still have to prove rape in this, which is a very difficult hurdle in the first place. So the fact that we're taking away this defense is merely just taking away the opportunity for somebody to not even be prosecuted on a very difficult case in the first place. Because they happen to be married to the person, and I think that it's just intuitional that intuitive, excuse me, that we should do this. So I'm looking forward to voting for this.
All right. Further comments? Delegate Conaway.
Thank you, Mr. Chairman. I would like to ask a question to make sure that I'm correct on this. This also deals with fourth degree sex crime, which doesn't have to necessarily be rape, but could be inappropriate touching. Is that correct?
That is correct.
Okay, thank you very much.
Thank you, Delegate McComas.
Thank you, Mr. Chair. I was just wondering, I understand Delegate Cox has some serious concerns about this. Is there any way that we could put some qualifications on it that would make you feel a little bit better? Something like what I was thinking of is possibly that if the parties live together, you can't claim it, but because evidently this gets involved when there's domestic violence. Like if my husband and I were not living together, and so for, let's say 3 months or something, and he comes over and decides, he wants some relations, and I say no, and yet they happen and it's against my will, then that would be, that really looks like a rape. Whereas if you're both in bed together, it's a lot harder to prove. So I'm just kind of wondering if there's a separation period if that would make it more, in other words, if you would feel better about it.
I think that you've kind of hitting on one of the bigger points of the bill that if she says no, that is rape, and it shouldn't, whether they're married or not. If she says no, then no means no, and that is a sexual assault. But I do have other questions, but Delegate Cox, if you want to respond to that, then I'm going to go to Fisher and Moon.
Well, thank you, Mr. Chair. So I just agree with Delegate McComas. That was really the interest I had, was that this does not, and what Delegate Conaway said too, this does not require any proof of rape under the fourth degree issue. That's I would vote for it otherwise. I mean, I think the issue there is you don't even have to prove any abuse at all. So that would be the only drawback. And I think it's potentially a catch-22 for people that, he said, she said at a point of touching rather than actual force, actual abuse, or actual failure to consent to sexual interaction.
But is that what the bill actually does? I mean, the bill actually, that's not what the bill does. So what the bill is that if a fourth degree sex offense is alleged, then that fourth degree sex offense can go forward. What this is doing is it gets rid of the ban or it gets rid of effectively stopping the charge right out of the gate because, hey, we're married, so I can commit a fourth degree sex offense against her.
Right. You still have to prove it.
Right. You still have to prove it.
Well, I had a case similar to this, and in a situation where you have protective orders, it's one thing, to litigate that is one thing. It's difficult enough. But then when you have a criminal action as well, I think it just raises the issue to a level that really shouldn't be when you're talking about touching. So anyway, that's a serious concern for people who are particularly, I think in a marriage relationship, you have some of the most important aspects of trust being involved. And when you can't, you're like Delegate McComas said, you're in bed together already. And that's actually the case I had. They were married, they were in bed together, and one couple alleged the other one touched them without their permission. I mean, that was the exact facts. And now this is opening up a criminal charge as well on top of that. So, that's my concern.
All right, Delegate Fisher, I'm sorry, Delegate Crutchfield to respond, and then Delegate Fisher.
Yeah. So Delegate Cox, I mean, to me, it just doesn't make sense to have a person that is not married be able to file a charge. And whereas we're saying here, that, okay, we're married, and so I can't file a charge for the same thing. I mean, that's what this is all about, allowing everybody who is connected and who feels that they have been criminalized in some kind of way, that they be able to file a charge against the other person. So it shouldn't matter whether you're married or not. The point is that you have done some kind of sexual offense to another person.
Delegate Fisher.
Thank you, Mr. Chair. I just wanted to add to the comments of you, Mr. Chair, and thank the bill sponsor for this legislation and subcommittee chairwoman Crutchfield. I mean, for me, the reality is, what's the difference between people that are domestic partners that are living together that still have that criminal charge for a 4th degree offense? It just doesn't make sense that marriage, just getting the marriage license itself, is the defense, because you could be saying having the same concerns that colleagues have brought up when how many Maryland couples are engaged and living together and they're not married. So it just really doesn't make sense. It's a common sense bill. It's protecting victims, and I think we should vote favorable.
Delegate Moon, then Cardin.
Thank you, Mr. Chair. I would just remind colleagues, the vote on this in committee last year was 19-1. The vote on the floor was 127-9. And I don't know that the 9 included even a single member of this committee. So with that, I get that there are outlier concerns about the language, but we already moved this overwhelmingly through the process last year. And with that, I would like to move the previous question.
I recognize Delegate Cardin, so we'll hear your motion to move the previous question after Delegate Cardin says what I presume will be relatively brief. Delegate Cardin.
Thank you, Mr. Chair. I just was going to say that I think that somebody already said, when you're trying to prove a case on 4th degree sex offense, if you're in bed together, you're married, and you touch somebody and they allege that you touched them, you are not going to be charged with or convicted of 4th degree sex offense. There has to be actual touching that is a little bit more intimate than that. And that's the issue, is that no is no, and it's pretty clear when it goes from touching to inappropriate touching. I move the question on behalf of
There's a motion for the previous question.
Second.
And second, and all right, all in favor of moving the previous question, say aye.
Aye.
Anyone opposed? Nobody opposed. All right, 1 nay on the moving the previous question. Then the question now is on the motion. The motion is a favorable motion on House Bill 147. We've had discussion, and we will call a roll call. Vice Chair.
Yes.
Delegate Anderson.
Aye.
Delegate Arakan.
Aye.
Bartlett.
Yes, of course.
Delegate Cardin.
yes.
Delegate Conway.
Yes.
Delegate Cox.
Nay.
Delegate Crutchfield.
Yes.
Delegate Deborah Davis.
Yes.
Delegate Juanica Fisher.
Yes, yes.
Delegate Grammer.
Yes.
Delegate Griffith.
Yes.
Delegate Lopez.
Yes.
Delegate Malone.
Yes.
Delegate McComas.
Yes.
Delegate Moon.
Yep.
Delegate Shetty.
Yes.
Delegate Cham.
Yes.
Delegate Watson.
Yes.
Delegate Williams.
Yes.
20-1. Off we go. All right, House Bill 243. There is an amendment. Delegate Cox has an amendment to 243. Delegate Cox, okay, here's how we're going to try and do this. As you can see, we're switching the screen to show everybody what's in the amendment. Obviously, this is going to be a little difficult for people at home, and we're going to try and work this out a little better. But if you would go, if committee staff would go and down to the pertinent language that well, that'll help too. There we go. Delegate Cox, is it safe to say that what is on the screen right now is the pertinent language that you wish to include in the bill, correct?
It looks like it. Yes, Mr. Chairman, yes.
All right, that's fine. All right, so Delegate Cox on your amendment.
Thank you, Mr. Chairman, and Madam Vice Chair. I appreciate you allowing me to bring this in, and I apologize. I think my staff might have got it in as fast as they could, and I think there was an issue there. We're going to make sure that improves if we have any additional amendments in the future. But the gist of this is, I think the vice chair's bill is to permit closer to a no-fault standard for divorce, and this amendment does not affect that. It just simply says that if the parties on their own prior to marriage choose to enter into prenuptial or premarital agreements to encourage counseling and mediation prior to divorce, that they must do that. If they produce documentation that they've completed it and still want to get the divorce, then obviously they can proceed. And so with that, I'd be happy to answer any questions.
All right. Are there questions for the maker of the amendment, the vice chair?
Thank you, Mr. Chair. I would say to Delegate Cox and to anyone who's proposing an amendment, if you could also get it to the bill sponsor, that would probably be appreciated all around and just as a courtesy. So this is the first time I'm taking a look at it, and I will argue against the amendment and urge everyone to vote against it. If you enter into a prenup with someone, that's a contract. And so you already have to abide by it. So if your written contract says that you have to obtain marital counseling and mediation prior to filing for divorce, there's no need for us to put it into a law because that's what you have to do. If somebody doesn't do that and goes ahead and files, then the other person could easily file a motion to dismiss and attach their written agreement and say, hey, we were supposed to go to counseling or mediation and that hadn't happened. So I don't think this is necessary for us to put in law because the parties would already have a contract that they have to comply with. And so I would urge the body to reject this amendment. Thank you, Mr. Chair.
Delegate Conaway.
Thank you, Mr. Chair. My question to Delegate Cox was, why should adults have to have marital counseling, even if they sign the contract? If they decide they want to get divorced, why can't they just get divorced?
Well, it's a great question, Delegate, and I think that the issue is along the lines of encouraging that if there was a prior agreement, then the courts should be able to look at that, and the courts should be able to point to a statute that says, you know what, really you should go try to obtain some counseling and mediation first. We already have a mediation standard in the courts, so this would, I think, encourage that to continue in a positive way, and there wouldn't be any reason if if that was attempted, and I know the way the mediations normally are, if you decline, if you show up in a mediation and say I'm not doing it and walk out, the mediator will say it's done. And so there, the design and encouragement is to support and build up marriages that could use maybe some counseling. And I've seen it happen in private practice. I've seen counseling save marriages. So I think this is a worthy opportunity, I think, to put in the law. And if I could respond to the vice chair as well.
Well, wait a minute. You were responding to me, so I'll give you a final response. We just passed something that deals with the fourth degree sex offense against your spouse. So things are changing, and even though you might go to counseling, or it might be a good idea, a counselor might not be able to help you with a problem like that. So now you can go to the vice chair. Thank you.
Thank you, Delegate.
Delegate Cox responding to the vice chair.
And I wanted to apologize. I was under the impression my staff had provided that to your office. So if that didn't occur, I just wanted to apologize that we didn't get that to you in advance. So thank you.
Thank you, Delegate Cox.
We're going to talk a little later about the amendment process because we're discovering some of the vagaries in the DLS process that have been less than perfect, but we wanted to, at least in this case, err on the side of hearing the amendment for this bill today, and I'll go into the procedural stuff a little bit later. All right. Are there any other questions for the maker of the amendment?
Yes, Chair, please, if I may.
Is that Delegate Cham?
Yes,
Delegate
yes.
Cham.
Thank you, sir. And Delegate Cox, if I understand your amendment correctly, if I'm reading it and understanding it correctly, is the amendment intended purpose to say the sanctity of marriage and give a couple who may be considering divorce time to consider that through counseling, through the use of counseling.
Thank you, Delegate. And yes, that's exactly the intent. And it also does not mandate this for everyone. It's just for those who had discussed this and entered into an agreement prior to marriage. It just gives the courts an ability to encourage that rather than either dismissing the case outright or ignoring the opportunity for counseling. So that's the intent.
Thank you.
All right, Delegate McComas.
Thank you, Mr. Chair. Just briefly, when the bill hit the floor, Delegate Dumais had an amendment that was put on the bill last year. And I just wanted to ask the sponsor, Delegate Atterbury, if the bill that she filed is the one that had basically where it got left out in the sense that it's what was passed out of the House with the amendment as opposed to what the bill originally came in at, introduced it a year ago.
Yes, Delegate McComas, this is what was passed out of the House.
Okay, thank you.
All right, and Delegate Arakan, please.
Thanks, Mr. Chair. So Delegate Cox, is it your belief that what Delegate Atterbury said is not going to cover the issue? I mean, she in her statement, she said that, you know, if one party brought the prenup to a judge and said, we have a prenup, she isn't following it, do you believe that the judge would not take that under consideration and then not grant the immediate divorce?
So there's a couple things. First of all, I would view this as a tool in the statute. And obviously, if you had a prenup without this amendment in the statute, the judge could make a couple decisions. One would be, as the vice chair said, he could dismiss the case potentially. That's probably unlikely, but there could be motions to stay the case, and most likely the judge would simply order the parties to discuss it. I mean, it depends on the judge, but ultimately, I think this is a tool to say it provides some clarity in that situation. It also provides a tool for people who are looking to marriage to say, look, we can look at this with a sense of encouragement to obtain counseling and have some sense of stability and some sense of opportunity to make sure we try to make this work before we file divorce for divorce. So although I think technically the case could probably be dismissed outright, this wouldn't necessarily, I mean, by this being in the statute, I think it would create an added incentive and opportunity for a judge to not just dismiss it per se, but to simply encourage that the contract be followed and that mediation and or counseling be obtained.
Would you not think that, I mean, if this is in the statute, I think maybe it may hamstring the judge. I mean, let's say there was some extenuating circumstances, the one party's leaving due to some sort of abuse or something, but they have this statute in there and they have a prenup. The judge, I feel like if your amendment was there, would say, I'm sorry, you have a prenup, you know what I mean? But in the case of just the language as it is, the judge could sort of look at all the factors and say, you do have a prenup, but given the gravity of the situation, I'm going to go ahead and grant this, even though you haven't fulfilled the prenup.
Well, and I think that would be the same case here. If there is a purpose or reason that would prevent a counseling, obviously for abuse, then that would simply be a matter of fact. I mean, you're not, whenever you have a protective order in place, you're forbidden from having contact anyway by law. So this would not affect that, or it would not hamstring the judge at all in that sense, if that's what you're meaning. And I think instead it would provide an opportunity for mediation, and particularly in the sense of child custody disputes. So I think it's a good added tool. It's already, like I said, the courts are already encouraging mediation, and this is an added tool, I think, to try to strengthen marriage in that sense, rather than continue down a path where a lot of confusion might set in, and parties might not feel like they had an equal opportunity to discuss the matter.
Okay, thank you. Thank you, Mr. Chairman.
I see Delegate Malone with his hand up for a question. I might be asking him a question here in a moment, so we'll see how this goes. It'll be fun for everyone. Delegate Malone.
Yes, I think there's a recent appellate case that said if there's a parenting plan that requires mediation before filing suit, that is not permissible. That agreement within a parenting plan cannot bar you from going forward with a divorce case. So what I would say is I'm not sure a prenup standing alone would hold water. Of course, if we pass a statute, then I think it does hold water.
Delegate Malone, I guess I would be troubled by the public policy that we're setting here that basically says, here is the prenup that you've now negotiated prior to the marriage, and now we're coming to the time when where some would be looking at divorce, but now I'm going to hold the prenup in front of the marriage and say, okay, well, you didn't abide by the prenup, so now we have to stay married for the rest of our lives. It strikes me that the marriage and the decision to enter into the divorce of the marriage trumps the prenup to some extent. The prenup is just what you agree to deal with assets and to deal with issues related to property and to children and visitation outside of the marriage and the court. Am I wrong in that?
I think actually that's what the appellate courts would rule.
Right. Oh,
without this statute. With this statute, it would establish new public policy.
Yeah, I would be deeply concerned, I think, by that public policy. Delegate Moon.
I was just going to make the same point you were, Mr. Chair. And so with that, I would suggest it sort of controverts the point a lot of us had for supporting the bill. I went and reviewed the vote on this one also, and it does not appear that we're going to be changing minds on this. So with that, I'd say if there's a motion on the amendment, we can look at it. Otherwise, I would move the bill.
Delegate Cox, do you wish to press your amendment?
Yes, Mr. Chair, and just briefly to explain, there is not a mandate, and if this were to pass, it's not a prevention to divorce. I just want to make that very clear. I put that in there specifically to ensure that the public policy would not controvert the opportunity under Section 2 there, or subsection 2. You can see that all you have to do is just submit the certificate that the mediation and counseling was attempted. So that with that, I would ask that the amendment be moved favorably.
I guess interestingly, in response to that, we've had another bill last year that talks about the get in the Orthodox community. And I think that marital counseling could be easily construed to say religious marital counseling. And so that could easily tie that into it too. But with that, he wishes to press the amendment. And so that's what we're going to do. And this is going to be our first amendment in this brave new world. So Delegate McComas, I'm sorry, I'll ask you to unraise your hand for a second, because here's how this is going to work. If you wish to vote for the amendment that has been put forward by Delegate Cox, I need to go to the raise hand feature and raise your hand. I'll give you about a minute to raise your hand, and then I will count the number of raised hands, and then we'll go from there. All right, I'm going to stop checking in about 15 seconds.
Sorry, what was I supposed to do?
Four, 3, 2, 1. The amendment fails. 4 votes in favor of the amendment and 17 votes against. All right, now we are on the bill. Is there a motion on the bill?
Move favorable.
There's a motion for a favorable. Is there a second?
Second.
There are many seconds. All right, is there further discussion on the bill? On the bill. Delegate McComas. Delegate McComas on the bill.
She's trying to unmute herself.
She is trying to unmute herself.
I apologize. I wanted to make a comment on the amendment, and we're past that because it had and I'll tell you what it was. It was prenuptial or premarital, and I was thinking prenuptial means premarital. I was wondering if it should be postmarital agreement, instead, because it's kind of like the same. They're the same. At least maybe they're not, but that's what I thought they were, is the same. So anyway, just forget it.
Okay. Are there further comments on the bill? Motion for a favorable? Seeing none, we'll go to a roll call. The vice chair,
Yes.
Delegate Anderson,
Yes.
Delegate Arakan,
Yes.
Delegate Bartlett,
Yes.
Delegate Cardin,
Yes.
Delegate Conway,
Yes.
Delegate Cox,
Nay.
Delegate Crutchfield,
Yes.
Delegate Deborah Davis,
Yes.
Delegate Juanita Fisher,
Yes.
Delegate Grammer,
Yes.
Delegate Griffith,
Yes.
Delegate Lopez,
Yes.
Delegate Malone,
No.
Delegate McComas, Delegate McComas. It's muted yourself, Delegate.
Unmute, sorry. Yes.
Delegate Moon,
Yes.
Delegate Shetty,
Yes.
Delegate Cham,
You're muted.
No.
okay. Delegate Watson,
Yes.
Delegate Williams, maybe getting her.
Yes, she had to go get her shot.
All right, committee, we're going to leave it open. I will leave it open for her, but it won't change the outcome, so that's fine. It will either be 17-3, or it'll be either 17-4 or 18-3. All right, I'm trying to be a little flexible because of the vaccines. All right, great. Moving right along to House Bill 289. House Bill 289. And there are no amendments that have been offered in a timely fashion. This is
Move
Delegate
favorable.
Atterbury's bill. There's a motion for a favorable. Is there a second?
Second.
There's discussion on House Bill 289. This has to do with peace orders in the workplace.
Can I just make a comment, Mr. Chair?
Delegate Arakan.
I think it's terrible that you're not letting us raise our hands and add our names to bills anymore, because I would love to co-sponsor that if you were allowing me.
Jeez, Mr. Chair.
I'm a horrible person, and now that's recorded and in the press. I really am going to be a horrible person, so that's fine. But there was a decision that came down from the Speaker's office. The added challenges, especially this year with adding further amendments, the way that we're going to have to go to the floor, anytime we add an amendment is going to add a lot more time this year, and that's why. So I apologize for that, but I'm very happy that you're enthusiastic about the bill. Delegate Cox.
I was going to ditto that, and I was a little confused from the rule because I was told by other Democrats in my delegation that there's a new rule that says that amendments to add your name in committee are now permissible. Is that not true?
That's not my understanding from the Speaker's office. If anything changes before the next voting session, I'll let you know.
Okay.
All right. Are there questions on the bill? All right. Seeing no further questions on the bill, the motion for a favorable and a second. Roll call. The Vice Chair.
Yes.
Anderson.
If Delegate Arakan is a co-sponsor, yes.
How about if she's not a co-sponsor? Are you still a yes?
Yeah, I'm still a yes, yeah.
All right. Arakan.
Yes, sir.
All right. Bartlett.
Yes.
Cardin.
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
Yes.
Yes.
Griffith,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Watson.
Yes.
Is she back? All right, I don't think that Delegate Williams is back. I'm going to leave it open for her just in case, but at the moment it's 20-0. The bill is passed in either case, so that's fine. All right, Delegate Moon, 324. There are no amendments in the file. No amendments have been offered. Is there a motion on the bill?
Move favorable.
Motion favorable in a second.
I'm sorry, which bill was this?
Yeah.
324. Delegate Moon, you want to give the elevator speech of what the bill does, please?
Maryland currently has decriminalized 10 grams of marijuana, and medical patients can carry 4 ounces. So this bill would move the general decriminalization amount from 10 grams to 1 ounce. This was Delegate Nick Mosby's bill last year that we passed. It was 93-44 on the floor. The vote was bipartisan on the floor. In committee, the vote was 17-4. The vote was also bipartisan in committee. You're welcome to vote how you want, but them's the facts. The Senate voted for the PWID part of this bill 45-1, so nearly unanimously in 2018. So yeah, with that, I would renew a favorable vote.
So motion for a favorable and a second. Is there further discussion on the bill? All right, Delegate McComas. Unmute.
Mr. Chair, I would just like to say in my review of this bill, the sheriffs and the police do not like this bill. The Harford County State's Attorney does not like this bill, and neither does the Baltimore County Attorney, Scott Schellenberger, like the bill. So in order to keep peace, at least in my district, I'm voting against the bill because these guys know a little bit more about this and they understand law enforcement, and they also understand the drug trade, and I think they understand the unintended consequences of what Delegate Moon is trying to do. So I'm voting against the bill.
Yeah, go ahead and get me a drink.
Delegate Malone wishes to get a drink.
Of Coca-Cola.
Of Coca-Cola.
Okay, all right, okay, if you say so.
We're on the last bill. It's the last bill, just the last, just hang on. All right.
Wink, wink.
All right, this has gone so wonderfully well up until now. All right, is there any further discussion on the bill? Hearing none, there's a motion for a favorable. By the way, some people are now just hearing these jokes, and it's fun to listen to people in the background here as they hear this happen later on. It's great. All right, motion for a favorable in a second. We're going to a roll call. The Vice Chair.
Yes.
Delegate Anderson.
Yes.
Erican.
No.
Bartlett.
Yes.
Cardin.
Yeah, I'm gonna, but I need a bag of Doritos along with this bill.
Delegate Conaway.
Yes.
Cox.
No.
Delegate Crutchfield.
Yes.
Delegate Deborah Davis.
Yes.
Delegate Juanika Fisher.
Yes, Mr. Chair.
Delegate Grammer.
Yes.
Delegate Griffith.
No.
Delegate Lopez.
Yes.
Delegate Malone.
No.
Delegate McComas.
No.
Delegate Moon.
Yes.
Delegate Shetty.
Yes.
Delegate Cham.
No.
Delegate Watson.
Yes.
There are 6 votes in the negative. 10, 13 votes in the positive. It won't change the ultimate result of the bill. So we will hold that open for as well. And that, I think, is that. That is the last bill we're voting on today. We got that done in a little under an hour, so that wasn't so we will be back for hearings on Tuesday with a number of bills on Tuesday, might be a little bit later. Hopefully the weather isn't too bad where you are this weekend, but please stay safe in any case. And we thank you all very much. Have a very good weekend.
Mr. Chair, wait. Were you going to talk about amendments, Mr. Chair?
Yeah, I'll touch on it a little bit right now. The rule, as I stated it on the first day, was that we want to have the amendment in the committee's hands 24 hours before the voting session. The challenge that we ran into was that there was a little confusion as to Delegate Cox's amendment because the amendment was requested by email weeks before, but they're not accepting amendment requests that way. There is a form you have to fill out online to submit an email, to submit an amendment request. That was done. The amendment got to the committee a little late. It got here this morning at about 9 o'clock. Being that perhaps we'll look at this as a little bit of a teachable moment, it's okay. But we're going to come out next week. We're talking to DLS about their timeframes and about whether they can hit the sort of the roadmaps that we've laid out, whether they can get amendments done that quickly to ensure that they get back to the committee a day before so that we can provide them to everybody and so that we can provide them more broadly to the public. So that we'll have a little more guidance next week, but that was the hiccup. That was the hiccup today. We'll come back next week with more specific rules of the road. Okay. But in any case, if you've created or if you've produced an amendment, it is always right to give it to the bill's sponsor so that you give them that courtesy at the very, very bare minimum. Okay. Now with that, we'll have more about that next week. Please have a good weekend and stay safe. Thank you all very much.